Okay, welcome everyone, and welcome Wilt. I'll pass the mic over to you. You can do your introductions, and I will be here in the background.
No problem. Thanks, Christina. Hello, everybody. Good morning or good afternoon already. For those of you in Victoria, good afternoon. If there's any interstaters, I don't know, probably all just Victoria. But I'm Tammy. I'm the Partnerships Manager at Wild. And here is my colleague, Brianna Lampkin. She's one of our lawyers here at Wild. She actually started over a year ago working with me in the
Yes.
partnerships team, but she's doing her law degree, and she has fully finished that. So she's now a proper lawyer and working in our law team. We have a fantastic law team here at Wild. Six of us. How many?
Yeah.
We've got paralegals, we've got lawyers, and really, as far as this whole online process, a lot of people today, what we're going to actually talk to you about is, some of the myths associated with writing a will, and there are a lot of them, but we're going to knock out the top 10, I think, today. And what we are going to talk about, or what Brianna will sort of cover, is really, reasons why you should have a will, what happens if you don't have a will, and some of the legal sort of jargon, definitions of words that we might have heard a few times but didn't understand quite what they meant. So Brianna will go through all of those, and we are open to answering questions at the end. I would just prefer, if anyone does have a question, we might actually answer it in the presentation. So if you could just hold off perhaps asking your questions. If we didn't answer it, we're happy to try and answer it at the end. And anything we can't answer, we'll get the answer for you. So we're going to share our screen, if that's okay with you, and we'll get going. Let's
And
see.
if just on questions, if you'd like, you can pop them in the chat as well, and then I can read them out at the end. It's no problem.
No problem. All right. So hopefully everybody can see this.
Yeah, perfect. Thanks.
All right, fantastic. All right, let's get started. Brianna?
Alrighty, I'll get started here. So the first thing that we want to address is the complications that dying without a will can cause. Now, it can cause heartache, headache, and financial havoc. So it can cause heartache as your loved ones will fail to inherit in the ways that you had intended, and it can create painful family disputes. It creates a headache as your next of kin and your relatives can't obtain a grant of probate as they ordinarily would if you had a will, and they may have a much harder time winding up your estate, talking to the bank, talking with your super, and dealing with your property. Financial havoc, as the assets and liabilities will need to be tracked down, collated by your next of kin. Meanwhile, all of your dependents will have to wait until that's done. Now, some of the legal terms that we'll be using today will be probate, next of kin, and your dependents. Now, probate is the legal process that happens when you die with a will, which is an application made to the court by a lawyer or by your next of kin or your executor. And then if you don't have a will, it's a different process called letters of administration. Now, your next of kin is usually your closest living blood relative. So if you have a spouse, it'll be your married partner. If you have a de facto spouse, it's your de facto partner. Then it's your children, your parents, your siblings, if none of those people beforehand are in the picture. Now, your financial dependent will be anyone who actually relies on you for support. So that's not always a blood relative. It might be stepchildren, adoptive children, could be, anyone you live with and relies on you. So that can become a complication as well when you pass away. Now, if you die intestate, that means you have no will. Here in Victoria, the person's estate, which includes all of their property after debts and funeral expenses are paid, it's distributed according to the rules set down in Victorian legislation, which are generally referred to as intestacy law. Now, each state will have its own legislation about allocating assets if you pass away without a will. If you don't have a will, you run the risk of the things that you own being given to the wrong people or people who you didn't intend for them to be given to. And then if you pass away without a will and no one makes an application, or your closest living next of kin doesn't, the state or the public trustee can actually make the application and they have the right to do so. Now, creating a will can cause calm, care, and contribution. So shows that your family that you care. You can leave assets and sentimental gifts to your next of kin, to charities, to anyone you really care about. This is not something that can happen if you don't have a will. Specific gifts like wedding rings, heirlooms. You can nominate a guardian for any children that you have that are under 18. Very important that you do this, because even if you have a partner, you don't always know if you're going to pass away at the same time, within 30 days of each other. You just don't know what can happen. So it's very important that you have someone who you can nominate as a guardian who you trust. And you can also provide for your pets and specify who you would like their owner to be should you and your partner pass away, or you and the other person who owns that pet passes away. And then also when you write a will, it's very important to consider doing a power of attorney. So this is, you can nominate someone to be able to make decisions for you after you lose capacity in that, if you do lose capacity. And it can also cause, bring you calm, and you'll feel relief essentially when you finish doing your will, knowing that you've taken care of your loved ones, you've planned your estate, you know how things will pan out after you pass away. And contribution. So you can leave and include charities and philanthropic causes that are close to your heart, and leave the world a better place if that's something you would like to do. Now, Tammy will discuss some of the common myths.
So we're going to knock out a few of the myths associated with writing a will. So one of them is, I'm too young to write a will. Well, the answer is that if you are over the age of 18, you should have a will. As confronting as it might be to write a will, some of us are afraid to consider the idea of death, especially when we have medical issues and things like that. However, every time you have an important life experience, you might get married, have children, travel, buying a home, use it as a reminder to update the manuscript that is your life, so your will. Another myth, I don't own enough or have enough assets. This is a typical myth that a lot of people think, well, I just don't need a will because I don't have enough. Well, wills aren't just created to divide your assets. They also authorize a trusted person, your close friend or family member, for assistance to act on your behalf. After all, you wouldn't want your grieving loved ones to be left to deal with it all, even by your phone company or the bank, who won't stop charging fees, mortgage payments, simply because they'll only speak to the owner of the account. So, plus, most of us own more than what we realise. Everything adds up. Your furniture, your car, your superannuation, and other belongings. So you might be surprised at how much you have accumulated over the years. And it's not just about your assets with financial worth. Think about sentimental things as well that you have at home, heirlooms for loved ones. It might be art, jewellery, things like that. And there are some obstacles to writing a will. Obviously, it's too much, it's too time-consuming, it's too confusing, it's too confronting. So these are some of the obstacles why people have not written a will. And so we're here to really help, knock out some of those reasons. And another one here, number 3, writing a will is too expensive. Well, that's no longer the case, especially with, the traditional way of writing a will may have been very expensive, but now you can write a will online. It's very cheap, or even free for that matter. Sometimes we offer amazing discounts. Another myth will be that making a will is very time consuming. Well, are we really that busy all the time that we can't make time for one of the most important things in our lives? So procrastination is really the number one reason people don't write their will. Most people intend on writing their will. They just keep leaving it to the last minute. But the minute you do start the will process, you will immediately feel that sense of relief and wonder why you didn't get it done sooner. And the online will process, which we're going to talk to you about at the end, it takes as little as 15 minutes to get your will done. So you can write a will in 15 minutes in a day, and I'm sure everyone has at least 15 minutes in their day to do that. One more myth here, number 5, is writing a will hasten my death. Now, and it is a very difficult topic sometimes to raise with people. Consciously, we know superstitions are irrational, yet the fear of jinxing ourselves brings about bringing about death in our attempt to try and manage it somehow is a very real one. And so we understand that, but it is a false one. So superstitions are not real. The average person can create between 2 to 4 wills in a lifetime. So clearly there's no correlation between drawing up your will and the end of your time here on Earth. But if there is a genuine concern for you, please know that you're not alone, okay? And talking about it with someone such as family member, a close friend, or a therapist can really, really help. So here we go. I'm going to pass it on to Brianna again, some of the important steps to take when you write a will.
Of course. So one of the first things that you'll need to consider is who you would like to be your executor. Your executor is the person who will be in charge of actually administering your estate after you pass away. So they're appointed. You can do 1 executor, 2, 3, you can just do 1 person, and then you can appoint a backup, and then that's something you can do in our online will as well. It's important to know that this person will need to be able to locate your will, talk to a funeral company, maybe assist in organising, your final assets. They need to apply for probate. They'll need to identify and collect all your assets. They'll need to pay off your debts, your taxes, and actually distribute it to the beneficiaries that you've appointed. So I would say it's very important to pick someone who, you trust. So common people that people choose is a family member, a close friend. Those people are also often beneficiaries under your will, so they actually have an interest in distributing your estate as soon as possible. Some people do a solicitor or a professional trustee company. At Wild, we're actually partnered with Australian Unity. So if you don't have anyone in your life who you feel like you want to make an executor, you can also do a professional executor such as Australian Unity. They do have a fee, but they do everything for you. Your family don't have to worry about it. So that's always an option. And a beneficiary can also be your executor, like we discussed. And then you can have multiple people jointly. Now, to actually choose your beneficiaries, that's the second most important thing. So a beneficiary is anyone that you choose to receive something from your estate when you pass away. You have full control over who you choose for your beneficiaries to be. They can be a family member, a friend, a charity, an organisation, or a trust. It's important when you're choosing who your beneficiaries are to consider who would be entitled to your estate should you pass away without a will. So if you have a spouse, if you have children, all of those people would be entitled to something in your estate. So it's important to consider, who you would like to be your beneficiary. If you're considering leaving anyone out, it's important to talk to a lawyer just in regards to the complications that can arise if you do that. With, leaving stuff to charities and organisations, it's important to talk to the charity and see, what the correct ABN would be to actually leave something to that charity. All right, now, so your executor will actually allocate your estate, and you can have beneficiaries, you can have charities as your beneficiaries. If you have children under 18, as discussed, you can choose a guardian who would care for them should you and their other parent or legal guardian pass away. If you have pets, you can appoint someone who would actually care for your pets should you pass away as well.
So here's another myth. Brianna might not know this, but I'm sure she does. I don't have a partner or children, so I don't need a will. Well, this is a shocking revelation we found. If a will feels irrelevant to you because you're not a parent or not in a committed relationship, consider the ramifications for everyone in your world. Here's an eye-opening example. Pop star Prince, who I'm sure you will all be familiar with. He actually died at the age of 57 in April of 2016, and to everyone's shock, he didn't have a will. Scores of claimants descended and resolving the ensuing legal drama, which took 6 years and multiple appeals and at a great legal price tag. But ultimately, who knows what Prince really wanted? As someone who was extremely philanthropic in his lifetime, it's reasonable to assume he would have had strong feelings about continuing to give back even after his death. Yet without a will, no one was able to determine this. So if there is a cause you're passionate about, be sure to make mention of it in your will, legally and formally. So don't assume that others will do it in your absence. And especially at good charities like Think Pink, your family may not even know that you have an affiliation to Think Pink. So important to include them in your will if you want to. Here's another myth. I'm married, so everything goes to my spouse, right? Well, essentially, yes, but in some circumstances, the answer could also be no. In today's world, with blended families increasingly becoming the norm, there are new and ever-changing complexities to this previously straightforward matter. Separation, divorce, subsequent marriages, children from the past relationships, and stepchildren can all impact your will's validity. Spousal laws do exist to ensure your partner is looked after upon your death, but these don't consider your partner's personal preferences. For this reason, it's important to discuss these scenarios with your spouse, sensitively, of course. Ask them to make the big decisions now, not while they're deep in their grief. All right, what else do we have to think about?
There are also some things that aren't included in your will. So even if you do have a will and you've, say, left 100% to your spouse and that's who your beneficiary is, super is not usually considered as a part of that 100% of your estate. It actually sits outside of the estate. So if you do have super or life insurance, it's important to make what's called a binding death nomination. You can call up your super or make contact with them. Sometimes you can do it on the online portal and actually choose someone who you would like to receive your super. Otherwise, if you have no nomination with your super company, your family members and your dependents will need to make claims with the super company. Multiple people can make claims. They don't know who you wanted your super to go to, which complicates things. You can also leave it to a beneficiary, or you can leave it to your legal personal representative, which will actually make it a part of your estate, and will leave your executor to distribute as per the estate, which would be 100% to whatever you've put in your will. So that's a very important step with your super and your insurance.
One more myth. We're knocking them out here. Number 8. Oh, my family knows what I want, so they can work it out. It's true, your loved ones know you the best, but that doesn't mean they know it all. Do they truly know how important it is to you to leave a certain amount of money to a beloved charity? Do they know everything about your assets, your shares? If you don't leave a specific document for them to follow, the chances of confusion, misinterpretation, and arguments can occur. The last thing you want your family after you pass away. The last thing you want for your family. All right, so Brianna, do we need to list all of our assets?
No, so in your will, you don't need to list all of your assets. You can distribute by percentage, you can give specific gifts, and that's the most important thing. If you want to give something to someone, it is important you mention it in your will, but otherwise not necessary.
How do I list specific items?
Yeah, so if there is something that you cherish, like a piece of jewelry, piece of artwork, something that you'd really like to go to a specific person, you can list that in your will as a gift. Otherwise, you can have all your assets split between percentages. And another thing that we recommend is to maintain a separate list of your assets anyways. So it might be something, you have your physical will, something you can store alongside your will but not attached to it. It's just a list of things you have at any given time. Obviously, wills are documents that you can have for a long time, so your assets change. And it's important to have a current list of assets that's separate from your will.
And how do we allocate our super again? I think this is it's something that we did mention.
Yeah, so as mentioned earlier, you should include your super. You can do that in the will with willed. It's not something that's automatic, but our legal, our lawyers here, me, a few of our other lawyers, we can add in that clause if that's something that you would like, which would direct it to your estate.
And what about clearing up my debts?
Yes, of course. So your debts and any funeral expenses, legal expenses, and gifts to charities or specific gifts in general, they're actually taken out of your estate first. So the thing that you divide by percentage is your residual estate, which is everything that's left after debts, funeral expenses, and gifts.
Okay. Fantastic. Can I have a backup beneficiary?
Yes, of course. So you can nominate a backup beneficiary. This is a very important step just in case that your primary beneficiary passes away or you and the primary beneficiary pass away at the same time or within 30 days of each other. Okay, so it's not always something you can expect. No time to update your will if that does happen, so it's important to have someone there as a backup.
You can include charities as a backup too.
Yes, you can.
That could be something to think about.
Of course.
Can I exclude certain children from my will?
Yes, you can exclude children. You have full testamentary freedom to have whoever you want as the beneficiary under your will. However, it does not prevent anyone from contesting your will. There is not a lot you can do about preventing your will from being contested other than leaving things, in equal shares to people who would be entitled. You can make a statement of wishes or a letter of wishes, which is just a statement to assist your executor should that happen. That just explains your reasons why you've left someone out of your will, and that's another thing that you would make separately to your will, and it would not be attached to your will. This is not legally binding. Yeah.
And when do minor children get access to what's in my will?
Of course. So if your minor children are beneficiaries under your will, or anyone under 18 are beneficiaries under your will, they won't receive anything until they reach the age of majority, which is 18, or in any other age that's indicated in the will. Your executor holds that inheritance on trust for them until they reach that age.
And how do I include a charity?
Of course. So you can nominate a charity very easily in your will, just usually the name of the charity and their ABN details. Leaving a bequest to charities on our website is very easy. We have a little pop-up section. You can choose all the charities that we're partnered with, or you can add someone that we're not partnered with as well. And it's very simple.
So some practical considerations. Can a will be digital only?
So no, a will can't be digital in itself. You must have a physical will. As long as it's, on the piece of paper, it's been signed by you, by two people who are your witnesses, only then does it become legally binding. Obviously, our wills are drafted and made online, but it still becomes a downloadable will that you can print off and make it legally binding.
And who can witness it again?
Anyone over 18, pretty much. We recommend that they're not an executor or a beneficiary under your will, or anyone else that's named in your will, as that can cause complications later on. But, it could be your neighbours, it could be justice of the peace, it could be pharmacists, anyone really.
And where should I store my will?
Of course. So the original version of your will that you've signed with the witnesses, that should be stored in a safe place. So that can be at home. You can do it in a safety deposit box with safe custody with, maybe a solicitor or a bank, anything like that. As long as, you tell your executor that you're storing it somewhere and that you do have a will and that they are the executor, that's the important bit, because that makes it easy for them actually to find your will after you've passed.
And what if I already have a will, but I need to now update my will?
Yeah, of course. So anytime that something significant changes in your life, being marriage, divorce, children, a beneficiary passes away, anything like that, we recommend that you create a new will. You can do codicils for your will, but we don't recommend that, and it's not something that we offer, as it can just complicate your will and it can create confusion for your executors and your beneficiaries as to what your wishes are. So if you want to change what's in your will, we recommend making a new one. If you have a will with our online platform Willed, we have an ongoing subscription. It's $15 a year. You can update your will as many times as you like. It's completely free to do, update for 12 months. And that way, if anything changes, it's a lot cheaper than making a new will every single time, or purchasing a new will every single time. But it is a completely new will. You can sign it, you can have it witnessed, and it will completely override your previous will. Okay?
Fantastic. So we're up to number 9. We've got only 2 more. Number 9, the myth of online wills are not legally binding. We have a lot of people that perhaps have family members who are solicitors and lawyers and might say to you that an online will is not legally binding. But here we are to nip that one in the backside, I should say. That is incorrect. The Online Wills platform was designed and created by lawyers. It's a digital template that has been designed very carefully by a team of lawyers to ensure that once downloaded, it's just as legal as a will that you get from a private solicitor. It also, what makes a legally binding will is not the drafted document, but it's the signing and the witnessing of the will.
Exactly.
Properly drafted will, however, can reduce confusion and issues once you pass away. And myth number 10, if I write my will once, it's done forever. Creating a will isn't a set and forget task, okay? So there are numerous life experiences and choices that can result in your will requiring amendments. These are things like getting married, divorce and separation, health conditions, traveling, starting a family, loss of a beneficiary, asset acquisition, loss and sale. You can get a codicil, like Brianna mentioned, through your lawyer, which is an added document to your will, but we do not recommend this as best practice. Best just to rewrite your will fresh, and anything written previously will become null and void. Now, we're at to the point where if you are ready to get started, if you need to write a will or if you want to upgrade your will, it's a simple process. You go to willed.com.au/thinkpink, because we are doing this through the charity Think Pink, and you'll come to a screen like this. That's what it looks like on your mobile or your laptop computer, and you would start the will by clicking on that Start Your Will. And you'll go through a sort of a registration point at this point. So it's going to ask you just a few simple questions like, are you over the age of 18? Where do you live? Relationship status, if you have children and pets. And once you've completed those few questions, you will then have to list your email address to create your account. And then you'll be given these 7 simple guided questions that you'll have to go through, which talks about you, your guardians, pets, executors, how you divide up the estate. And when you get to question number 6, that's all about the gifts, if you'd like to consider leaving a gift in the will. And the last point is any funeral wishes. Here at Willed, we also take care of cremations and prepaid funerals, and it's a fantastic service as well. So you can list those things in your will, and when you get to the end and you've finished everything, you would download it. When you get to question 6, though, it's going to bring up a very simple, would you like to add Think Pink? And that's because you've gone through the Think Pink custom page. This is optional, obviously. You know, we're not forcing anybody to leave a gift to a charity, but if it is something you'd like to do, a monetary gift or a percentage of your estate, even as 1%, and even possessions you might want to leave to them or something like that, it's worth considering. You can then add other charities and other people when you're at this point. And you can chat with us live at any time. If you see right down the bottom there, there's a little orange chat with us live. We are open 7 days a week, our online services. So unlike a solicitor who's probably only available 5 days a week during business hours, we are available 7 days a week. So at any point of the will process, we can answer your questions. We have a fantastic customer support team, and you can get a call back from a lawyer like Brianna, who can call you back if you have any legal questions that you would like answered. And we also offer every single person that writes a will with us a free legal review. So it is upon request. So if you get to the end and you would like one of our lawyers to review the will, you simply email it to us and we will have our legal team review it for you. For today, we're offering all of you that have registered with the seminar today or the webinar a discount. We're going to give you 50% off your will until the end of August. So if you log on to willed.com.au/thinkpink and you enter the code thinkpink50 at the end, you'll see there's an apply code. The will be reduced to $79. So the normal cost of our wills are $159, but we're going to give it to you for $79. So it's a fantastic deal. And that's running until the end of August for you people that have registered today. So we are available for any questions if anybody would like to ask.
We've had a few questions in the chat. So we have Kathy said, you mentioned you can have multiple executors jointly. Can they separate for the easier management in the role?
Yeah, so in our wills, if you appoint more than one executor at the same time, they are usually acting jointly. which means, so even if they are jointly, one of them can still renounce if, for example, after you pass away, they find that, they aren't going to be able to administer your estate for whatever reason. Maybe they're living in a different country or something's happened. One of them can still renounce and leave the other person to act by themselves. But generally, if you appoint two executors, those two executors are going to act together in making the application for probate after you pass away and in administering your estate.
And Kathy also asked, if someone contests a will, is the legal cost taken out of the will asset, even if the contesting person was determined to not have an entitlement?
Yeah, so that is a good question. Here at Willed, we don't really deal with contested estates. But if, for example, your executor does need to engage a solicitor to defend your estate essentially against a claim, it is possible that that the legal cost of the solicitor could come out of the estate. And if, there might be an agreement as to cost between the solicitor for the claimant and the solicitor for your executor, which might impact your estate. Yeah.
If you leave super to your personal representative, will it automatically attract 15% tax for the taxable component, even if it's going to your spouse?
Yeah, so that would be something, we can't give tax advice, and it'd be something very specific to the super company, I imagine. If something's left to your estate, it shouldn't have any tax when it goes to your beneficiaries. There is no inheritance tax here in Australia. There is only tax when it actually is sold after your beneficiary has received that asset. For example, if they inherit a house and they sell that house, there might be some tax implications there. But otherwise, if it's left to your estate, if your super's left to your estate and it's divided as per your estate, there should not be tax involved.
Is a non-legal person, such as a beneficiary, permitted to assist a parent to create a will using online or will package wording?
Yeah, so if you need assistance with making the will, being that you need help with using a computer or the online platform, as long as you have capacity to understand that you're making a will, you know who you want your assets to go to, you understand the implications of making a will, that's perfectly fine. The only thing I would suggest, if you're going to have someone else assist you with making a will, prepare that maybe after you pass away, that might be a question raised as to who made your will, if people have concerns about that, but that's quite an easy thing to address. So I would say yes, they can assist you.
And just sort of touching on, you mentioned sometimes you have free wills. Some of our clients can be in financial hardship, so $79 can sometimes be quite a lot. If you just want to sort of explain that a little bit.
Yeah, sometimes we do run different campaigns, and some of our other charity partners sometimes, depending on, look, we have different packages that we partner up with different charities, and so depending on the sort of the package that they've chosen, some of those charities do get free will months. But if it's someone that's really struggling, and we are happy to offer Think Pink an opportunity to give that person a free will. We have gift cards, we have ways that we can offer that. So it is up to Think Pink then to give out a free will if they would like to. And that's something that we can discuss with Think Pink together. But, most of the time, generally for the general public and for you today, we would give a 50% discount. Look, there are other, online will providers that you can get a free will. I think that the problem around the free will, and I'm not saying, that a free will is bad or anything like that, but I feel that a lot of people that start a free will don't end up completing it. Because they haven't really had to pay for anything. It's free. They don't tend to take it very seriously, and so they leave it. Whereas if you've had to pay for your will, you tend to take it a bit more seriously, and you get to the end of the process and make sure you've executed the will properly. Because a will that hasn't been executed properly, especially someone that chooses to leave money to beneficiaries or to charities, when you do come to probate time, if a will hasn't been properly executed, we cannot grant, or the money can't be granted to the charity or to the beneficiary. So it's really important that somebody values the will process. And so we do understand there are definitely people out there struggling. So through Think Pink, we can arrange something for those people.
Beautiful. Another one came through. Do all pages of the will need to be initialed or signed, or neither?
Yeah, correct. So every single page of your will needs to be signed. We recommend you do your normal signature. So, whatever you sign on your driver's license or passport with, or sign documents with, that's the signature that you should use for your will. You and your witnesses will need to sign every single page. It's very important that you do this. Let's say, after you pass away, if your will isn't signed on every page, the court have no way of knowing if that page was in your presence when you actually signed the will. So that could lead to some questions about, if that page was taken out, swapped with a different page, why isn't it signed? That can cause some issues. It is usually easy to address, but we would recommend that you definitely sign every page.
Something else that we offer, if someone's living here in Victoria, if they're finding it difficult to even find two witnesses, they can always come into the willed office and our lawyers can act as witnesses for them. So that's something that we also provide services.
Are your wills written in plain English? Do you have a sample available?
Yeah, so they are written in plain English. They still use legal terms such as testator, beneficiary, but they're very easy to understand. We don't use terms like testatrix or any convoluted legal words. And there is a list of definitions in the will as well. So, if someone is concerned about what the definition of a certain word is in the will, they can refer to it, children for as such as defined. We don't have a sample available only because that is kind of what our product is, but it's about 7 pages. It's split into clauses. It's got executive powers. It's quite properly.
We do have a sample of Homer Simpson has a will with us, and we do have a sample of his will that we could share to Think Pink. And if anybody would like a copy of that, you can certainly hand that out to them.
That's all the questions in the chat. I guess I'll open it up to the floor. If you have a question, feel free to come off mute and ask your question.
I had one. Sorry. Yeah. What if you wanted to set up a trust or something like that if you've got young children?
Yeah. So if you want to set up a testamentary trust, being that it's a trust that's included in your will, which would take effect when you pass away, which would allow money to be given to your children in stages or held for them for a certain amount of time. It's not something our online will can account for. It's a lot more complicated than the online will.
Okay.
Is for. So if you'd like to do a testamentary trust, I recommend speaking to a solicitor, as the online will wouldn't be sufficient for that. We do, gifts to minors, or it's automatically held on trust by the executor until they're 18. But it's not a formal trust. It's just the executor's responsibility to keep that.
Do a bit of reading as well, because I wasn't sure even the difference. Is a discretionary trust the same as a testamentary?
Testamentary trust is one that only takes effect after you pass away.
Okay, because I've heard of discretionary and a bare trust. I don't know the difference yet. I'll do a bit of reading.
Other sorts of trusts you can make while you're still alive. So if you would like to hold assets, for certain people and beneficiaries while you're still alive, you can do that with a discretionary trust or a different type of trust. But a testamentary trust is one that's included in your will, which is for your beneficiaries after you pass.
Yeah, cool. Thank you.
Yeah.
All right. Another
one
question.
just sort of flipped in the chat. Sorry. Is it possible to leave a gift to a family member executor for their time and effort in managing probate?
Absolutely. So if you'd like to leave a specific gift to your executor, you can do so in gifts. You can for probate, your executor will be able to reimburse themselves for the cost of actually obtaining probate. So whether that be the solicitor fees, the court fees, they can actually take that out of your estate. However, for their time and effort, that is something that you can leave a specific gift to. It's usually called something like an executor's commission. They can also apply for this with the court if it's not provided for. So you can do that.
Cool. Anyone else in the chat have a question? Yeah, go for it.
So I got another one. So with super, do you know the difference between leaving it like going to your estate or nominating directly to beneficiaries?
Of course. So if it's left to your estate, that means it's divided alongside all of your other assets under your will. If it's left to a specific beneficiary that you've nominated, then it's not divided with your will. So if you have $200,000 in super, for example, and you nominate a certain person to receive that super, it'll just go directly to them. If you nominate it to your legal personal representative and then your estate in your will is split 50-50, your super will be split 50-50 alongside that.
And you don't know if there's different tax implications with that?
There can be. However, I'm not qualified to give you any sort of tax advice. So I would recommend you speak to your super company. They should have a good idea about what the difference is, or you can also speak to your accountant in regards to that.
Yeah. Okay. Thanks.
We have a where are you located?
We're in Garden Vale, Victoria, so that's just next to Brighton, kind of, southeast. So if you are nearby, you're more than welcome to come in if you want assistance.
We're moving though in 3 months.
We are moving.
We've outgrown ourselves here at Wild. We've become a massive team. So we're moving to Brighton East, so not far down the road, Brighton East. But our office is always open. Anyone welcome to come in if they'd like to make an appointment, speak with one of our legal lawyers about something, they can do that. And on our website, there's lots and lots of frequently asked questions if people have things they want to know. We have another question here. What's to stop someone from taking any of my possessions after I've passed away?
A little bit of a tricky question. Do you mean your physical possessions or your bank account or anything like that? If it's something like your bank account, that would be generally frozen. So it would be up to your next of kin or your executor to let people know that you've passed away so that no one can touch those assets. If it's physical things, I suppose, you would just have to ensure that your family know that that might be a concern of yours. Let your executor know, this is where my things are, this is what I have, and then they will know if something is missing. That's what I would generally recommend.
That's why Brianna mentioned earlier, making a list of your assets on a separate document is really important, and sharing that with your executor so that they know specifically what items you have and where you want them to go.
Mm-hmm. Yeah, and if anything goes missing, your executor would be able to sort that out, whether it be with the police, with another solicitor, they would be able to sort it out.
Family aren't close to me, so they would be the ones to take it.
Okay. If you're not close with your family, your executor can always be a friend, or you can do a professional executor as well. And then that way it's someone who's separate from the situation, who might be able to deal with everything. Okay?
Yeah, and Wild has a partnership with Australian Unity, who can act as professional executors on your behalf. They do have their own fees and charges. It is on our website. But the good thing about choosing Australian Unity, if you don't know who to choose as an executor, is there's no upfront fees with them. They do take the fees out of the will. So it comes out at the end of life. So, yeah, if you're not sure who to nominate as an executor, our friends at Australian Unity can talk to you for free consultation. But they're great option if you don't know who to nominate.
Someone's also asked what's the cost to have a face-to-face appointment with Wild. If you're doing one of our online wills and you're paying for one of our online wills, there's no cost if you would like to come in and you have any questions, or if you would just like to have it signed and witnessed. We don't charge for that. You're already paying for the will, and that's included. And is there a body that checks that the executor has strictly followed the will? Not necessarily. The court, so your executor might be required to put forward the records of what they've done to the court after probate has been granted. Usually your beneficiaries will know. if they haven't received something. So sometimes that can be a good idea to have a separate executor to a beneficiary. Otherwise, not necessarily. If your executor's not doing their job, your beneficiaries can take action on that, and then, things can be sorted out. It could just be expensive if that happens.
All right. As we said, on our website, there is a live chat button. At any time, you can ask our customer support team questions. You can ask for a callback from one of our lawyers, and we will be able to give you the answers. And anyone that does have a more complex will, a bespoke will, things like that, we would recommend that you would speak to a solicitor. The online wills is really just if you've got a more simple estate, simple will. So if it's a very complex type of will, we would recommend that you speak to a solicitor. Yeah. All right.
Thank you so much.
Absolutely pleasure. We really appreciate you having us today. And
Likewise.
if anyone does have questions, again, just go to the website. And here again, we're offering that 50% off to anybody that would like to write a will. Just go to the website, add /ThinkPink. We'll pop the link into the chat here for anyone that wants to go on right away. Just to register with us is free. It's only at the end that you'll be asked to pay the fee, and just apply that code ThinkPink50. There you go. I'll put that in the chat there. So thanks so much again for having us.
Thank you. We really appreciate it. And yes, visit the website if you'd like a will, and if you'd like to reach out to these lovely ladies. If you could pass on the Homer Simpson will, would be
great. Yes, will do. I'll email that through to you. No problem.
Thank you. But yeah, thanks everyone for coming and participating as well. It's been so great.
Not a problem. Have a great day. Bye-bye.
Take care, everyone.
Thanks for organising. Thanks. Thank you both.